Good morning. Again, a complicated question arose when I appeared in a pokso case, and particularly pokso case, rape cases, 420 cases, 138 cases. This important area should be concentrated. I request the beloved friends, additional public prosecutors, assistant public prosecutor, district and city public prosecutors to go through the final report before you sign for approval of the final report filed by the police officials. And they may have some limited knowledge of law, but having much experience in field of the criminal side. The additional assistant public prosecutor would concentrate on several provisions, because the final report being prepared at the first page of final report, followed by the list of witnesses and document and accompanied by the documents, must contain the sections and the name of the accused and there about the precise history of the prosecution case. You must go through that and also go through the every statements. Here in my case, what had happened, the allegation of the girl, minor girl, and the pokso case was that there were two maternal uncles along with she was residing, because her mother died and father left her mother deserted. She at the time of alleged complaint was studying 10th standard and claiming to be under the age of 16 years. She says some few occasions, without mentioning date or the year, one of the accused, one of the maternal uncle, used to touch her private parts and showed the phone through his cellulose. That allegation was against one uncle. And she also differently alleged against another maternal uncle also. He also did the same things, and on particular date, even the 161 statement, there was no date, but she seems to have mentioned the particular date in 164 statement. These all are available 173. But unfortunately, the state representative inspector of police, Aluman police station, failed to file different charge sheet. He filed a common charge sheet against both the accused. And according to me, I do not want to discuss because that may prejudice my client. I will discuss that later on. Now, kindly go through these provisions where they say the CRPC 220, 219 says 3 offences of same kind within year may be charged. Then section 71 of the Indian Penal Code, 71 of Indian Penal Code says that 71 of Indian Penal Code go with the Pokso Act, where the Pokso Act prohibits double punishment for IPC section as well as Pokso section. So the graver punishment alone be awarded. This is also restricted under section 71 of the IPC. Then important sections is that what persons may be charged jointly. That person accused of same offences committed in the course of same transaction, abatement upon attempt to commit such offence, persons accused of more than one offence of the same kind within the meaning of 290. Then persons accused of different offences committed in the course of the same transaction. Thereafter some few sections are which is logically correct. Then still they say 223, provided where number of persons charged with separate offence separate do not fall within categories of specified in this section, the magistrate may, if such person by an application writing so desire, or if it's satisfied that such person would not be judicially affected thereby, and is expected to so try all such person together. So that was there. This is what my humble submission. This area of filing charge sheet jointly is not legally tenable. I leave to that area. But what will we benefit for the defense lawyers? You can straight away raise an objection. Suppose one person's running a cheat and cheated in the name of company, he is liable for having cheated the company. Suppose he stopped, independently cheats any person, collects the money. So it may not be same transaction according to me, and up to appreciation of and finality of the judicial verdict about that area. Like that you can say, suppose two persons are entering into one hotel, and one person fight with the server and other person rob the, both are entering in the same transaction. But when there is no absolutely same transaction meeting of mind between the accused, filing charge sheet against both the accused is not legally tenable. However, I would like to get over this, but like that you have to go through, first you go through the final report and go through the statement, whether these are within the same transaction, if there are multiple of the accused, you can shake. And my humble request that I want to consciously praise the public prosecutor who concentrate much on this subject. And this is not that that everybody is born with intelligence. This you experience also cause you intelligence and reading. And my another humble request is, if you want to read any papers, you read in the early morning, 3 to 4, 4 to 5, 5 to 6, before sunrise. That will be very far better to acquire knowledge, and all that you read and perceived will be stored as a computer's storage. This is my experience right from the beginning of my career, that was taught by my mother, that Brahmavelai, before sunrises, if you read, that will be sticking to your brain chips. This is what I say. So the another pokso case distinction is this, and it's not only restricted to pokso case. You can apply your mind if a multiple number of accused is charged without imputing allegations about the same transaction, or within a abatement, all this. If the manager collects the fund in the name of the company and disappropriates without keeping promise, luring them to it, and the staff independently lures some other person and appropriate without depositing or without any transaction with the company, means it's a totally different transaction. This is according to my argument. Like that you can say that if any person suppose going both and one person enter into a shop and robbed and went away with the booty. Thereafter, on seeing this, if any other person enters and also does the same, this is not the same transaction, because there was no meeting of mind between accused 1 and accused 2 and 3. Therefore, there may not be a jointer unless and until we file an application under 219 CRPC. So 219 CRPC, because I am going to file 219 CRPC 4, subclass 4, because there is no use of conducting different trial. If it is a common trial, it is benefit for me. I understand that. But as a lawyer, as a officers of the court, I want to assist the court, as well as I want to enlighten the prosecutors and police officials who are indulging in these cases to concentrate on these matters. When cases are reported on a different footing. Best wishes.